landscapes were had quail focal areas nested within those, which were either WMAs or other pieces of public ground that had high potential for doing restoration work. So with that, in 2017, we got our first partnership positions here in the state with the Game and Fish Commission and with NRCS. I moved down here initially as the senior pharmacobiologist in Central Arkansas, and then we hired 6 other pharmacobiologists at the same time or later that year. And as you can see, those pharmacobiologists were nested within those quail focal landscapes to really try to ramp up efforts in those areas and have a concentrated effort to really have an impact locally on that habitat and actually see good results of the work by really having that focused effort. 4 years later, here in 2021, we've expanded the partnership still more. I'm now the state coordinator. We have a regional representative in the state to work with our chapter folks. We have 2 more state level positions, Leslie Cooper, the monarch coordinator. We also have a grasslands and grazing coordinating biologist that covers statewide responsibility that's doing a lot of work on monitoring efforts to see the results via quail and songbird surveys, as well as pollinator and monarch surveys. And he also works across the state with native grazing, promoting native grazing for both better production for our cattle producers, as well as increased wildlife habitat on grazing acres. And we've increased to 8 pharmacobiologists. So just a little recap of that. Starting in August of 2017 with the initial position, 6 more that December, and then adding positions over the next few years. That extra pharmacobiologist was through a NIFWIF agreement with NRCS dollars and NIFWIF and Arkansas Game and Fish Commission providing match to add an extra specific working lands for wildlife biologist position there in Izard County. So we've added 11 pharmacobiologists and partner staff just in the past 3 to 4 years here in the state. And this is just an example of the impact that those biologists can have. This map showing the site visits that our biologists completed just in FY19. And you can see that it's really impactful having these folks and targeting that effort. Some folks really targeting effort across their work area in specific locations around those quail focal areas that are WMAs or public lands. And then this is our total site visits for the first 3 fiscal years of having staff on the ground here in the state. So just some accomplishments of the partnership so far. We're well above this now. These accomplishments run through the end of last fiscal year. So when we get our next annual report, I'll be able to update these. I'm sure by now we're well over 500 plans written, 200 contracts, 1,300 site visits. Our team's really focused on doing landowner outreach and trying to engage the public and get more people interested in doing habitat work. We do a lot of landowner workshops in any given year, and we've really ramped up our online profile and doing a lot of Zoom workshops as well this year. But by the end of last fiscal year, we were over 200 with 5,700 participants in those workshops. Our total acres planned so far, and these are acres of actual contracted on the ground implementation of habitat at the end of last fiscal year, was over 46,000. And one key thing for me there was, if you look at the bottom line here, of those 46,000 acres, 32,500 of those acres were considered monarch and our pollinator habitat. So these were quality acres with either planted seed mixes that were high diversity, included milkweed, or restoration of natural landscapes that was going to encourage native forb and milkweed growth in those new areas, whether it was woodland thinning and burning or management of prairie systems or old field areas. One other thing that we're excited about here in the state that's a more recent development is we've also added a 5-person habitat specialist burn crew. This burn crew is a partnership with the Arkansas Game and Fish Commission. They are tasked specifically with going out and doing the on-the-ground implementation of the wildlife habitat planning work from either The Quail Forever Farm biologists are the Game and Fish Commission private lands biologists, and they work exclusively in the Ozarks, Ouachitas, and Arkansas River Valley regions of the state. This crew is focused on doing the on-the-ground work for our private landowners, whether it's prescribed fire, planting native seeds, spraying out non-native areas, invasive species control, timber stand improvement, pretty much any habitat work that we would plan. This crew has the ability to go out and do. And thanks to the Game and Fish Commission, this crew's out there on the landscape every day, conducting this habitat work absolutely free of charge for landowners if they're not in a cost share program. So it's a great program, and it's really helping us get more work on the ground. And just like our farm bill biologists, this habitat crew is also ranking these projects and specifically targeting projects that are either nested next to other existing projects or nested close to those quail focal areas to try to really expand that local landscape and build off of existing habitat to have an even larger impact on the landscape level. And just all of this work that we do here in the state, all of the work that we do anywhere with the way that we work is really thanks to our partners. And here in Arkansas, it's been fantastic. Our partners have been just wonderful to work with. It's been an excellent partnership here in the state. And we can't say enough to thank all of our partners for these positions and what we do here. So with that, I'm going to turn it over to Leslie Cooper to talk about our monarch and pollinator work.
Thanks, Ryan. So really the key part of this is that as Quail Forever, we're really focused on more than quail, and I'll kind of go into that
right here.
In the upper right hand corner. There's one of our many native bee species, so we benefit a lot of our native pollinators in addition to other wildlife species. So, we've talked about monarch and pollinator habitat, and this really varies. I try to, highlight what monarch and pollinator habitat truly is. So when I say monarch and pollinator habitat, really talking about, an area that has a high diversity of native species that blooms throughout the entire growing season. So it provides a constant supply of nectar and pollen to our native pollinators. It has a wide diversity of flower sizes and shapes and structures because a lot of our native pollinators are specialists, so they only pollinate certain species. And of course, it includes native milkweeds because milkweed species are, the one host plant for monarch butterfly larvae. So there are actually 21 native species of milkweed in Arkansas. So we try to include multiple species in each of our, habitat restoration projects. So, but the key part when I talk about monarch and pollinator habitat is that we're really managing it to benefit all pollinators and other wildlife species like bobwhite quail, turkey, deer, and so on. So the best part about the, farm bill biologists and our habitat specialist crews, we're integrating this monarch and pollinator habitat into existing habitat projects. So, we're really just increasing the conservation value of these existing practices. So pollinator habitat can be integrated into native grazing. So it has a diversity of native forbs that support pollinators in addition to, forage quality for the cattle. The native seeding projects have a high diversity. I think a majority of the ecoregion specific seed mixes that we've created have over 60 native species, with most of them having less than 10 grass species. And really, it goes beyond just regular seeding projects. It also, accounts for different management activities that Ryan, kind of hinted at. The timber stand improvement and prescribed fire ties into the restoration for our open woodlands and plain savannas that we see here in Arkansas. So not all pollinator habitat has to be seeded. And also, our biologists provide technical assistance for habitat on rights of way. So this includes solar arrays and, road size, natural gas pipelines, many different areas that are often overlooked. So one part of my position is coordinating for the Arkansas Monarch Conservation Partnership. We have over 30 active partners that work through our steering committee, and then we have 3 subcommittees. And the Arkansas Monarch Conservation Partnership was formed in 2015 in response to 2 decades of decline of monarch butterfly populations. So in May of 2018, they finalized the Arkansas Monarch and Pollinator Conservation Plan. So like I mentioned before, monarch and pollinator habitat really benefits a multitude of species. So when the group was writing this plan, they found it very, very important to include the and pollinator part. So the habitat that we're creating and promoting on the landscape is really meant to benefit not only monarch butterflies, but our other native pollinators as well. So the plan has 5 major sections. The first one, of course, is habitat conservation, enhancement, and restoration. So there's 3 different habitat goals. One is specifically for private land, another for public land, and then a 3rd category for the public and private rights of way that I kind of mentioned earlier. The second section is specifically for research and monitoring, and this, this section of the plan is focused mainly on monarch butterflies, but also on native bee species. And then there's the outreach and education section. This group has accomplished a lot. And of course, the capacity, governance, and funding and collaborations and partnership sections are very important for keeping the partnership as an established entity. And if you're interested in getting a copy of the plan, either you can email me or you can go to our website at arkansasmonarchs.org. It's undergoing revisions currently. So if you keep checking back, you may see the change. So, part of my job is providing conservation technical assistance to private landowners and putting on trainings for state and federal staff for monarch and pollinator habitat and conservation. I already mentioned that I was the coordinator for the Arkansas Monarch Conservation Partnership, so I do quite a bit of outreach events, but I'm also training staff in several different monitoring protocols, and I try to be a resource for everyone in the state for anything monarch and pollinator related.
So just wrapping up real quick here with our presentation, we just wanted to share a few photos of our team and our staff out there doing what they do on the landscape every day. We have one picture there on the bottom left-hand corner of a youth pollinator habitat event where we had a bunch of 4th graders out. Actually, this is at I believe this was at the Pinnacle Mountain State Park, and we seeded an area to pollinator habitat, and the 4th graders just love that work. And creating good quality habitat on public lands is always a fantastic thing. And we had to include a picture of milkweed here as well. One last thing we just wanted to remind everybody, or put it out there, we do have a Quail Forever license plate in the state to help support all of this work that's going on the ground. All the funds from this license plate stay here in the state and go directly back in the ground into habitat work or landowner assistance. So with that, we're concluded, and we'll take any questions if there are any. And thank you all very much for the opportunity to come and talk in front of you.
I do have a question. What size acreage do you need? And is it CRP? And give me some of the requirements for some land that needs to be in, that can be in it.
So a lot of programs don't have any minimum requirements to have your land in that program. Most federal programs are open to any size landowner. It kind of depends on what your goals are. If you're wanting to improve land for monarchs and pollinators, every little bit helps, whether it's your front yard or whether it's a 40-acre field. Planting that high diversity native forb and milkweed component is going to be extremely beneficial for those pollinators, monarchs, and quail and deer and turkey. If you're really targeting trying to improve quail habitat, again, I don't like to tell people that we can't have an impact on the landscape. Whether it's a 5-acre field that you can do, that's great. You're definitely going to be relying and hoping that you can get your neighbors on board and doing some habitat work as well. But in general, if you can get 20 to 40 acres of quality habitat, you should be able to at least maintain a covey of quail on your property in most years.
I was wondering, I have a couple of 100 acres in the CRP that might be interested in it.
Yeah, so with a couple 100 acres, there's a lot of opportunity, and more than enough there to be able to support a decent population on your farm for sure.
The other question I had, we have a real bad hog problem in this area, and I know hogs root and tear up a lot of your nest. What is that? Is that I know it's detriment, but is that a stopper, or can we work around it?
That would definitely be something that you would want to try to address that problem as well. So hogs, like any other predators, are definitely not the key reason for a lack of quail on the landscape here in the state. It's definitely a lack of the necessary type of habitat that we need for quail. So that early successional and or native prairie type habitat that's open, has a lot of open space, grasses and forbs. A lot of times you see a lot of feral hogs in areas where I wouldn't necessarily call it the best quality quail habitat, so it might not be the largest issue, but I certainly highly recommend, and I know that the state's doing a really good job trying to really work on controlling that feral hog population. So you can get assistance for sure from the private lands biologist with the Game and Fish Commission to help with that issue at the same time as we do habitat improvement. And that'd be a good idea to do.
Okay, I appreciate that. Thank you.
Ryan, for someone like Commissioner Moss or anyone else, of course, who was interested in learning more about the programs and hopefully putting it to work on their own land, would you recommend they contact the local USDA person or local Game and Fish, or contact one of y'all with Quail Forever first to get this thing started?
Either way would work fine. So that you have our contact information here on the screen. You're welcome to call me and I can get you in touch with, if you want to talk with a Quail Forever biologist, we can steer you in the right direction. I believe I sent our staff map out, and so hopefully everybody has access to that, or Judge Moulton will share that with everybody. So if you're interested in quail and you want to talk to a Quail Forever biologist, you should have access to that. Otherwise, your private lands biologist or the NRCS office are excellent resources and can get you steered in the right direction as well. If you contact your NRCS office and you tell them that you're interested in wildlife, they will help you also get in contact with either your Quail Forever or local Game and Fish private lands biologist, or even your local forester, depending on your landscape and what you're needing to do.
Any other questions from other commissioners?
Mr. Chairman, I'd just like to make a statement if I could. I definitely appreciate Ryan and Leslie's presentation today. And just to give everybody a little context, when we started our quail effort really hot and heavy in 2016, we realized very quickly that with 9 private lands biologists, which is all that the state could offer, that equates to about 8.5 counties per person. And when we really started our push, if we were to get 4 or 5 new people per county, we would really there's no way our staff could deliver. And so much like how we do things in Arkansas, we were able to find some partners to partner with, and obviously Quail Forever and NRCS stepped up to the plate. And I know, as Director Keogh can acknowledge, that if you can bring on 9 more people and only pay half the salary from a state perspective, that is always a win. And so ultimately we were able to double our private lands capacity in the state. And if you think about the state, we're about 87% private land. So the public land side will never bring this species back or a lot of these other species. It's going to be working with private landowners to be able to do that. And it's really great to have partners like Quail Forever and others. And I could list a whole ton of other partners that help us. But I mean, that's really how we're going to make a difference. So appreciate the presentation today.
Again, I'll apologize for interrupting y'all at the first. I didn't realize my cell phone was tied to my iPad.
No worries at all. That's perfectly fine. And thank you very much. And thank you, Chris, for the comments.
I have a question, Leslie, for you. Commissioner Moss had asked Ryan about, acreage and that sort of thing with certain programs in mind. What about yourself, just with the pollinator and the monarch programs? Is there a minimum size piece of property that you need before you think it would be worth the effort there?
It's a great question, Miles. So one thing that I realized after I was done speaking that I forgot to mention, really any size habitat can benefit monarchs and pollinators. I myself am renting a house. I had 7 milkweed plants in terracotta pots in my front yard. And I actually had a monarch visitor last spring. So hopefully I'll have one again this year. And she laid literally hundreds of monarch eggs on my plants. So, I think that really just speaks to the importance of, kind of an all hands on deck, like Chris mentioned, Arkansas is mostly private lands. So as I mentioned, we focus on rights of way, private lands, public lands, but also, it's real. If anything's going to bring the monarch back and really save our native pollinators, it's going to be everyone working together to create habitat in spaces that they have control over. So really, there is no minimum habitat size. To benefit some of our native bee species, they talk about having, smaller patches connected together, similar to supporting several coveys of quail. But the important thing is remembering to plant native species. And, if anyone has any questions about, what to plant or what they can do to benefit monarchs and pollinators, I welcome them to either call me or email me, and I'd be happy to point them in the right direction.
Thank you. Any other questions from the commission? Well, thank you both for the presentation. And I can say firsthand, I've seen the work that y'all do, and it's absolutely fabulous. And I'd be remiss without bragging on the great work from some of your partners that I'm aware of there at Game and Fish Commission, Commissioner Carl Clayser, and Commissioner Ward sitting over there to your side, Commissioner Fox, and the work that the guys there at the Division of Forestry have done as well have just been fantastic. And all you guys combined with USDA have really made an impact, and we appreciate it. We're glad you're here. I believe this brings us on to the next session. Judge Moulton, you're up.
All right, thank you, Mr. Chairman. And again, my apologies to the commission. This technology is wonderful, but it does occasionally have its challenges. So we are on Arkansas PBS right now. We actually got to stream, I believe, the entirety of Ryan and Leslie's presentation, so I'm happy for that. Unfortunately, Secretary Keogh, you were not on PBS. We missed that part of this meeting, but we are live now. So I've got 2 matters for the commission's consideration. The first one up is a recommended decision dismissing, and it was a motion to dismiss filed by the entity that asked for the appeal in the matter of Two Rivers Harbor POA. Nobody has asked for an oral argument on that matter. Unless there are some questions from the commission, I would respectfully request a motion and vote in favor of that recommendation, Mr. Chairman.
Mr. Chairman, I move we affirm the judge's recommendation.
I'll second that.
You're muted, Miles.
Yes, I'll second it.
Thank you, Commissioner Holland. All in favor, say aye.
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 All opposed? All right, thank you. Motion carries. Judge Moulton.
I'm sorry, Mr. Chairman, I think we temporarily lost Commissioner Reynolds again, but I believe he is back. Is that right, Commissioner Reynolds?
No.
Maybe not. I can see his phone number. All right, my apologies again. So the next item I have for the commission's consideration is in the matter of Elemental Environmental Solutions, LLC. There has been a request for oral argument on this recommendation. I believe Mr. Flowers for Clean Harbors is going to be arguing on behalf of Clean Harbors, and then Mr. Spencer and Ms. Rothamel are going to be arguing. Mr. Spencer is going to be arguing on behalf of Elemental Environmental Solutions, and Ms. Rothamel is going to be arguing on behalf of the Division of Environmental Quality. Under Rule 8, each side gets 15 minutes. Let me start with Mr. Flowers. How much time, Mr. Flowers, do you want for your presentation?
12 minutes and 3 minutes of rebuttal, Your Honor.
Thank you so much.
Is Bushman there?
Yep. Yep.
Okay.
And Bushman, are you taking this down, ma'am? Ms. Harper?
Yes, sir.
All right, thank you so much.
Mhm.
All right, and then the next, Mr. Spencer, are you on?
Yes, I am, Judge.
All right, how much have you discussed with Ms. Rothamel how you're going to split your time?
Yes, I have. Well, in limited fashion, yes. I don't think she's going to request that much time, but I'll let her speak to that. But I mean, I'm planning on taking 10 minutes.
Ms. Rothamel?
At the most, Your Honor, I may take 2,
Okay. All right.
if that.
I'll go ahead and keep the time. Let me get my time set up and structured. Let's see here. All right. All right, you said three minutes for rebuttal, Mr. Flowers, is that right?
Yes, Your Honor.
All right, I'm going to give you about a minute before your 12 minutes is up, just to let you know, all right?
Yes, sir.
All right. The floor is yours, Mr. Flowers. Please proceed.
Thank you, Judge Moulton, and thank you to the commission for the opportunity to speak before you today. My name, as Judge Moulton said, is Bruce Flowers. I'm here on behalf of my law firm, Kane, Russell, Coleman, Logan, and our client, Clean Harbors. As you may know, Clean Harbors has a large waste incinerator operation in El Dorado, Arkansas. But the question for today is what is appropriate under the rules of this commission when the end of a filing period, in this case, a 30-day filing period, falls on a Saturday, Sunday, or legal holiday, which of course would include days when the commission offices are closed. Most businesses are closed, and individuals are generally enjoying time away from the office. Of course, it would also include with legal holidays, holidays such as 4th of July, Thanksgiving, Christmas, and we just think it is an inappropriate time to require filing. But from a legal standpoint, in answering the question of when such a filing should be made, we can look at 3 regulations or procedural rules. First, we look at Regulation 8 generally. Then we look more specifically at Regulation 8.611, and then Rule 6A of the Arkansas Rules of Civil Procedure. So first, let's discuss Regulation 8. As you probably know, it governs administrative procedures before the commission, but it does not in itself provide an answer to our question of what happens when the end day of a filing period falls on a Saturday, Sunday, or legal holiday. Because Rule 8 does not answer the question, then it invokes Rule 8.611, which states, and I quote, "Procedural matters not addressed in this chapter shall be governed by the provisions of Arkansas Rules of Civil Procedure." This is not unusual. For example, in this matter, our discovery periods are governed by the Arkansas Rules of Civil Procedure. Now, looking at Arkansas Rules of Civil Procedure, we focus on Rule 6A. And Rule 6A governs the computation of time periods and does answer our question. I'll offer it does answer our question concerning filing dates. Rule 6A states that in computing any period of time, the last day of the period shall be included unless, and I quote again, unless it is a Saturday, Sunday, legal holiday, or other day when the clerk's office is closed, in which event the period runs until the end of the next day the clerk's office is open. So simply put, under Rule 6A, the last day of the period that falls on a Saturday, Sunday, or legal holiday, it is not included. The filing period is extended to the end of the next business day. Now, specific to this matter, it's undisputed that the end of the 30-day period fell on Saturday, December the 12th. And it's also undisputed that our filing request for hearing was submitted on the next business day, the following Monday, which was December 14th, 2020. So as such, I would offer that our filing was consistent with Regulation 8 and with Rule 6A, and the filing was timely. Now I'd like to dig just a little bit deeper and discuss the intent of Regulation H, because I offer that the intent of Regulation H is important to the Commission's decisions. And near the beginning of the regulation, I believe it's 8.102B, it states that Reg 8 is intended to be liberally construed so as to provide a fair opportunity for a hearing in all matters addressed within that chapter. Besides this being the express wording of the regulation, we offer this is also because permitting decisions they're just important. The issues are often complex, and a person should be provided an opportunity to be heard when disputing the merits of a permitting decision. Now, let me recap very briefly. I apologize for from a legal perspective. We know that 8.611 controls because there's no provision in Regulation 8 that discusses when a request for hearing or other such filing is on a Saturday, Sunday, or legal holiday, or when the clerk's office is closed. As such, the filing is governed again by the Arkansas Rules of Civil Procedure, and specifically Rule 6A, which provides that the last day of the filing period, it falls on one of those days, Saturday, Sunday, or legal holiday, the period is extended until the next business day, and thus, again, I would offer that our filing was timely. But having discussed what I believe is a clear legal answer to the question, let me also offer the Commission some reasons why extending the filing date until the next business day is the right and the best answer for the Commission and for people seeking to appeal a permitting decision. First, as I've discussed, the extension of the date to the next business day is consistent with the intent and with the language of Reg 8 and Arkansas Rules of Procedure 6A. But it's also very important to know that the present regulations state only that the Commission Secretary, and I quote, may accept facsimile or electronic mail copies for filing. I would offer that I suspect that the Commission would not have a party or person rely upon the term may in requiring that a filing be made on a weekend or legal holiday. I would also offer that there's no valid purpose in as furthered by requiring a filing on a date that the Commission offices are closed. And a person should not, appealing a permit decision should not be required to, on a non-work day or legal holiday, again, Thanksgiving, Christmas, make a filing to a office that's closed. It also, for persons, there are some people that just simply don't have the means to file documents electronically. And I'd offer that requiring them to file electronically on a weekend or holiday would be unfairly disadvantaging them to file on the day when the office is closed. It's just, it would be beyond their means. Lastly, I'd offer to promulgate or adopt a rule requiring the filing to be submitted on Saturday, Sunday, or legal holiday when the commission office is closed would constitute rulemaking rather than the decision-making. It'd be inappropriate to impose this without a meeting with public notice, hearing, and process. As I stated earlier in the beginning, Clean Harbors operates a waste incinerator in El Dorado, Arkansas. We filed a request for hearing in this case in an effort to establish a level playing field between waste incinerators in Arkansas. This is a result that I hope we would all welcome. For these reasons, and the reasons set forth in our briefing that we've submitted, we pray that the commission, after reviewing the record, considering the law and the facts, determined that our request for hearing was timely filed, and in so doing, reverse the recommended decision dismissing the filing as untimely. Thank you.
Thank you, Mr. Flowers. It took about 8.5 minutes, so you've got an abundant amount of time left for your rebuttal, about 6.5 minutes. Mr. Spencer, I'm sorry, I'm looking at the screen over here on my left, and I'm trying to find you. I guess let me reset this if I could.
Now, Judge Moulton, this is Mr. Spencer. I do need to raise a procedural issue before my time starts. And I couldn't have raised it until I heard Mr. Flowers speak because I wasn't sure in which capacity he was presenting his argument. And I heard him say he's representing Kane Russell, his firm, and Clean Harbors today. I consulted the record, the docket, and the motion that was filed to admit Mr. Flowers pro hoc vice and was submitted to admit him to represent Clean Harbors only, not Kane Russell. He's not admitted to practice in Arkansas. Mr. Riddle is. And so therefore I would submit, for the record that he cannot provide testimony in support of his representation of Kane Russell. I know the request for hearing was filed on behalf of both. I think it said request for hearing filed on behalf of Kane Russell and or Clean Harbors. I just wanted to make that distinction for the record.
That's fine. And frankly, all those issues had already been briefed. I did not reach the decision on the merits of any of those issues that were raised by the parties because I felt it was basically at that juncture, once I dismissed it on the timeliness basis, it was the functional equivalent of an advisory opinion on things that didn't matter anymore. So you can obviously raise it and make a record on it. But I'm going to recommend that the commission go ahead and listen to what Mr. Flowers had to say. And we've already crossed that bridge, Mr. Spencer, at this point. So let's just focus on the time element and see what the commission has to say about that.
Thank you, Judge.
Let me go ahead and start your time. Go ahead, Mr. Spencer.
All right. Good morning, Mr. Chairman, Commissioners, Judge Moulton. My name is Stuart Spencer with Mitchell Williams, and I'm here today representing Elemental Environmental Solutions, LLC, or EES. In a nutshell, Mr. Flowers is wrong. Judge Moulton is right. Kane Russell and Clean Harbors filed a late permit appeal. They admit that they filed their appeal more than 30 calendar days after DEQ issued the EES Title V air permit. The commission's rules are clear that an untimely filed request for hearing shall be dismissed. In other words, dismissal is mandatory. And that's exactly what Judge Moulton did in his order number 8. He dismissed the appeal because Kane Russell and Clean Harbors missed their deadline to file their request for hearing with the commission secretary. And the parties to this appeal are all subject to the same rules and the same statutes. We should all expect to be treated fairly and consistently under the rules. The rules create a level playing field, and to deviate from them would create an unfair advantage. EES respectfully asks you, commissioners, to follow Judge Moulton's roadmap for dismissal, within which he applied your rules, your playbook, to render his recommended decision. Judge Moulton correctly determined that Kane Russell and Clean Harbor's request for hearing must be dismissed pursuant to Rule 8.603. His recommended decision is supported by the law and the record in this matter, and Kane Russell and Clean Harbors offer no meritorious basis for the commission to reconsider Judge Moulton's recommendation. Accordingly, we respectfully request that you adopt the recommended decision without modification by entering Judge Moulton's proposed minute order. I submit to you that to take any other course of action would provide special treatment to Kane Russell and Clean Harbors and would also deny them of the level playing field they have requested numerous times in the pleadings they have filed in this proceeding. In order number 8, Judge Moulton performed a simple application of the undisputed facts in this matter to the commission's clear and unambiguous rules. The arguments raised by Kane Russell and Clean Harbors in their request have no merit, and the majority of them were already considered and rejected by Judge Moulton. The new arguments should not be considered, and even if they are taken into consideration, they're unpersuasive and do not change the fact that the appeal was late, nor do they provide a valid justification for filing late. If anything, they prove that Kane Russell and Clean Harbors had their request for hearing ready to be filed by the filing deadline, and that they ultimately ended up doing so electronically after the time to file had passed. Pursuant to the commission's rules, a request for hearing must be filed within 30 calendar days from the date DEQ issues its permitting decision. In this case, DEQ issued its decision on November 12th, 2020. The 30 calendar day period expired on December 12th, 2020. Yet Clean Harbors or Kane Russell did not file their request for hearing until December 14th, 2 days after that period expired. None of these facts are disputed. Rule 8.603 mandates that a late filed request for hearing shall be dismissed unless good cause is shown for the late filing. Here, Kane Russell or Clean Harbors, neither one of them have offered a good reason for the late filing. The deadline fell on a Saturday. Lawyers work on Saturday. But Clean Harbors could have filed its request via electronic mail on that day. And as the recommended decision notes, the commission's rules, Rule 8.606 expressly permits filings via electronic mail, and after hours and weekend filings are commonplace. Now, Kane Russell and Clean Harbors argue that the commission's rules are vague or unclear regarding when requests for hearings should be filed. This is wrong. Their argument fails because the method for computing the deadline to file the request is addressed by the commission's regulations. Rule 8.603B2 explicitly instructs that the 30-day period must be counted in calendar days, not business days, not working days, not days, but calendar days. Therefore, Rule 8.611 is not triggered, and the rules of civil procedure do not apply. Judge Moulton correctly rejected this argument in his recommended decision when he stated as follows: Rule 8.611 is not applicable because when a request for hearing is due regarding a permit appeal is not an instance where a procedural matter is not addressed in Rule 8. On the contrary, the filing deadline contained in Rule 8.603B is explicit and clearly and unambiguously states that a request for hearing is to be filed with the commission within 30 calendar days after the date of the director's final decision. Accordingly, we submit that the commission is required to dismiss the untimely request for hearing pursuant to your rules, and we ask that Judge Moulton's recommended decision be entered without reconsideration. He was correct in his analysis of the facts and the pertinent law. We therefore ask you, commissioners, to enter the minute order without modification. Thank you.
Thank you, Mr. Spencer. You took a little shy of 6 minutes. Ms. Rothermel?
Morning, Judge. Good morning, Commissioners. I'm Tracy Rothermel, and I am here on behalf of DEQ this morning. Because my argument would be substantially similar to what Mr. Spencer has just stated, I'm simply going to state that my client supports Judge Moulton's recommended decision and request that it be adopted.
Ms. Rothman, you took all of 20 seconds. How about that?
I knew it would be short. I'd like to reserve the rest of that minute and a half just in case.
Well, I don't know if you get to, yeah, I suppose you don't really get to reserve. So, Mr. Flowers, we're back to you. You have 6 minutes, sir.
Thank you, Your Honor. One thing that I would comment at the beginning that be very conscious of the fact that you did not hear from Mr. Spencer, with all due respect, what happens when the end of a filing period occurs on a Saturday, Sunday, or a legal holiday. The 30-day period is a 30-day period. We don't have any disagreement with that. Under the rules of civil procedure, a 30-day period is a 30-day period. You either have calendar days or business days. If you have business days, you have no need of a rule for Saturdays, Sundays, and legal holidays. It's only because it's calendar days that, in fact, you need that rule. And that rule is, in, at least in my knowledge, in every rule of civil procedure, because it's important. What happens when the due date falls on a Saturday, Sunday, or legal holiday? And the answer under the civil rules are very clear. It is that it is pushed to the next business day. And I would offer that's not just a legal premise, it makes sense because people shouldn't have to leave church or Christmas dinner or something to go and file. And while he's correct, lawyers occasionally probably seem like you, work on Saturdays sometime. Not everybody does, and not everybody should have to. It serves no purpose. The commission's office is not there to accept the filing. Nobody's going to look at it and consider it. And so I would just offer that the correct decision, and it's not just for my client, it is, I'm arguing for my client, but it is for the people of Arkansas also, is that as the intent is to provide liberal construction, and I'm not even sure what is liberally construed here, but it's liberal construction, so that the people have a fair opportunity to dispute or to question and operate a decision, permitting decision. And so I would offer for these reasons and the reasons that I set forth before, that requiring a filing on a Saturday, Sunday, or legal holiday is just very problematic. And while, again, I'm arguing for my client today, it is not something that should be done by decision making to impose essentially a new rule on the people in Arkansas, the people who file comments, because it is not in the rules. It's certainly not clear in the rules. Saturday, Sunday, and legal holiday are not connected to the filing times in Regulation 8. It's just not. And the people who put together Regulation 8 had foresight to say, hey, if there's some procedural rule that's not addressed here, then you looked at 8.611, which is, I think, one sentence, and it says it'll be handled by the Arkansas Rules of Civil Procedure. You also heard, did not hear anything I will say from Mr. Spencer arguing against the fact that 8.611 would direct you to Arkansas Rules of Procedure, or that 6A says anything other than what I've said, and that is that the date pushes forward. There's not actually a due date on that Saturday or Sunday. The due date is pushed forward to the next business day. So thank you for your time. I appreciate it. And we would again ask that the recommended decision be reversed. Thank you.
All right, thank you, Mr. Flowers. Commissioners, now is your opportunity to ask questions of counsel. You can ask questions of Mr. Flowers. You can ask questions of Mr. Spencer. You can ask questions of Ms. Rothmel, and of course, excuse me, you can ask questions of me if you so desire. Mr. Chairman, I'll turn it back over to you if the commission has any questions.
Thank you, Judge. Commissioners, if you have any questions, please speak up.
Mr. Chairman, I have one to Mr. Flowers.
Commissioner Melton.
Mr. Flowers, as a consultant that spends pretty much all of my time doing due diligence, they're pretty familiar with the standard of care. And standard of care requires that I be diligent. And then when I start something, I need to understand the rules and the regulations of which I'm going to be operating and with the authorities having jurisdiction I'm working with. And it strikes me that you were not diligent in inquiring about this and waiting until well after the fact to try to bring this up. And I guess I'm troubled by the fact that you had this ready on Friday and that the rule is quite clear. There are calendar days. That's inclusive of weekends and holidays. And it really doesn't make any difference whether we work on holidays or weekends. And I've done both, but the rule is clear. It says calendar days. And to me, it's your responsibility to understand those rules. And if you have questions, I would think that your standard of care would require that you inquire of someone and not wait till after the fact to try to argue that what we're doing is a rulemaking, which I think is mildly insulting. But I'll give it to you. I understand the passion and your zeal, but to me, this is very clear. It says calendar days, and I don't see how we get into administrative law when it's very clear. And it appears to me you didn't bother to try to find out what the rules were.
Thank you, Mr. Milton. We actually did do due diligence. There is no opinion or there is no order that answers this question. This is essentially a question of first impression for the group today. And I think it's important, a very important question, because it will, going forward, tell people what the standard is. But we made a conscious decision. We were working with the ADEQ to try to reach some type of resolution without having to file a request for hearing. That was our goal. And we did due diligence, and under the civil rules of procedure, Monday is the appropriate date. And I would offer again, and maybe I haven't made this clear, it is not that we differ with 30 days. 30 days it's a calendar days. The reason that whether you are required to follow on a Saturday, Sunday, or legal holiday is important is how do you compute that time? Under Rule 6A, you do not count Saturday, Sunday, or legal holidays, and you count the next business day, which is what we did here. And that's why I would offer that our filing on the Monday, the 14th, the next business day, was timely. It would certainly be timely under the rules of civil procedure. There's no argument otherwise. So thank you for your question.
There are other questions from the commission.
Yes, this is David Vandegrift. I have a question for Mr. Spencer. As a practicing lawyer, if I'd looked at these rules, I would have, based on 44 years of experience, assumed that a deadline that occurs on a Saturday, a Sunday, or a holiday means that the filing date is extended to the following business day. I don't see any case law in your brief that covers that issue. Did you look for any? Are there just no cases anywhere in the state or in other states that explain what happens when an administrative rule specifies a deadline that ends on a calendar day that also ends on a Saturday, Sunday, or holiday?
Yeah, thank you for the question, Commissioner. So what we did was when we went about writing our brief and doing the research for it, we looked at the reg specifically the explicit language in it. And I mean, I guess first I'd like to draw out that the rule itself does make a distinction between, they use the term days, it uses the term days, calendar days, business days, even working days. So there is a distinction where those specific different kinds of days are written into the rule. And I will also say that there are explicit examples of where an extender is provided. Like if it's a comment period on a draft comment, then a weekend extender is provided to that Monday. Here, there was no extender. So there are instances in the rule where that is provided. There was the absence of that extender here. So we thought that that was extremely relevant to the analysis of the deadline hitting on that day. And also, I would like to draw a distinction between what about something Mr. Flowers said. The rule does not compel a filing on the 30th calendar day. It says you may file up to 30 calendar days. So it doesn't compel that happen on the 30th day. That was a roll of the dice that Mr. Flowers and his firm took to file at that time. They could have filed any time before. And, you know, as the commission's rules explicitly state, electronic filings are commonplace. I mean, they may be received, and what happens is the electronic filing is lodged, followed up by a hard copy filing. So that's commonplace.
Ms. Spencer, you remember my question?
Case law, or was there any specific case law? I wouldn't disagree with Mr. Flowers that this may be a case of first impression for this commission.
Mr. Chair, I have a question of Ms. Rothermel.
Yes, go right ahead.
Has this occurred in the past, and have we a policy on that? Or has
Not that-
DEQ a policy?
Sorry, not that we have found. Once this issue was brought up, we went back and looked. I looked as far as I could possibly go and did not find a specific instance where a deadline fell on a Saturday and it was then filed on a Monday, or on a holiday where it was then filed late. So no, sir. It seems to be first impression for the commission as far as this question. Regarding case law going after that, in order for there to be case law in Arkansas, it would have to be case law interpreting the commission's decision or deciding the commission's decision regarding Reg 8. So you wouldn't find that if we didn't have it already.
My other question would be, we routinely, I assume, get filings on the weekends and holidays. I have friends who are jurists and attorneys and prosecutors, and I know they receive and they file things on holidays and weekends. Is that the case with the commission?
I've seen that happen. I've done that. I try not to wait for a deadline. So I have been known to file things on Friday, Saturday, Sunday, holidays, just to get it in before a deadline, just in case something happens.
Thank you.
Mr. Chair,
Commissioner Fox,
I move to adopt the recommended decision.
do we have a second?
Second.
We have an appropriate motion on the floor to adopt this. All in favor, say aye.
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 Any opposed?
No.
We have one opposed. The ayes have it. Thank you, Commissioner.
Give it to Vandergriff.
Bengal abstains.
One abstention,
White abstains.
2 abstentions.
White and Vanderver.
No. White and Bengal abstained,
Okay.
and Vandergriff was a no.
Okay.
All right, commissioners, I think that concludes the presentation, at least on my end. I don't know if, Mr. Chairman, anyone has anything else to weigh in. And again, my apologies. While I was trying to get things lined up with Arkansas PBS to live stream this, did you go over the possibility of meetings starting up live again? And did you go over the possibility of having a retreat in the fall?
We did, and both of those points seem to have been well received by the commission.
All right.
We'll rely on you and Ms. Goff to help us figure out some options on the retreat.
Okay. Again, my apologies.
Anything else from any other commissioners?
Mr. Chairman,
Yes.
I have some. This is Becky White. I have something for Patty. On the Senate Bill 517, I was muted, and so I need to abstain from that. I didn't get my mute off in time.
Okay, thank you. Thank you, Commissioner White. We've got it.
Okay, if there's nothing else, thank you all again. Go Hogs, and we'll see you at the next commission meeting.
Thank you.
Bye all.
Everybody.
Thank you.
Aye.